I'm from a very small town of 600 people. I never thought someone from the town that I'm from would be going before the Supreme Court.
In 2025, Todd Wages found himself and his vaping company in the chambers of the U.S. Supreme Court.
Justices heard oral arguments in a crucial case for the e-cigarette industry.
Supreme Court will weigh in on federal regulators' decision to block sweet-flavored vapes and e-cigarettes.
This is for all the people who shared the same mission that I did when I very first started, and was just to stop smoking. I remember sitting there in such a surreal moment. I see Chief Justice John Roberts walk out, I see Sotomayor, I see Kagan, I see Thomas, Alito. Oh, these people are real people, right? Because you've never seen them before in person. It was so interesting to hear the arguments from both sides. So that's kind of where we are today. We're awaiting a decision out of the Supreme Court.
Days after this interview was filmed, the Supreme Court ruled 9-0 against Todd and his company. This decision effectively ended Todd's business of manufacturing flavored vaping products in the United States.
I was a smoker, I smoked a pack a day, and I had tried everything from the patch to the gum. Those were the two options that I tried, and I didn't quit smoking. And I walked into this vape shop to kind of see what all the craze was about. I started using the product, and I started smoking less and less and less, and then I just accidentally quit.
Todd was moved by his experience, and he began opening his own vape shops.
I felt my purpose in life at that time was to help as many people stop smoking as I possibly could. What I saw after I started a vape shop is I learned that it was very difficult to get product a lot. Because the biggest thing is we would run out of product and then we would have to wait 2 weeks, and then customers would scramble, try to go to this shop, this shop, this shop, just finding anything that they could so they would stop smoking. It was at that moment that I realized that I could form a business creating e-liquid to really help with distribution and really help move the needle as far as supply chain issues go.
Unlike the flood of high nicotine disposable vapes, many of them gray market and unmonitored, Todd sees Triton's refillable products, made with pharmaceutical grade ingredients in clean room facilities, as a safer, more transparent alternative to the growing disposable vape market. In order to sell flavored e-liquids, Todd needed to get approval from the FDA. So his company submitted a PMTA. A year later, the FDA denied his application, along with 1 million other requests from similar companies. The FDA would only authorize these products if they believed that doing so would protect public health, and the companies had not provided enough evidence to support that claim. But Todd didn't see it that way.
That's whenever I had to look into my next options, and I said, I guess I'm gonna have to sue the FDA. And that's wild for me.
What followed was a legal battle that spanned 4 years, ending with the Supreme Court upholding the FDA's denial of flavored e-cigarette products.
Respondents' nicotine solutions for e-cigarettes are flavored to taste like fruit, candy, or various desserts.
Why is the flavor of e-liquids like cotton candy, ice blue raz, or rainbow road so important to the FDA? Basically, because they believe these flavors are appealing to kids and teenagers.
FDA denied their applications, concluding that respondents failed to show that their products have sufficient benefits for existing smokers to offset the serious risk that the flavors pose to attracting youth to the use of tobacco.
The data for youth is that the majority of youth do identify flavorants as a motivation for starting. Some youth even believe that the only thing in the product is flavorants. They don't realize all the other constituents. But obviously, nicotine dependence is a known outcome of e-cigarettes that's very concerning. And in youth whose neurologic development is not fully mature till the age of 25 has detrimental impacts on that, as well as increases the likelihood of long-term dependence.
Killer custard was mentioned as far as being child appealing, things like that. Obviously, you can see packaging. It's very simple, not appealing. They say vaping attracts youth, vaping attracts youth, vaping attracts youth. We can't take the risk of hooking a future generation on nicotine. My answer to that has always been the same. Can you please show me the group of youth that are using our products? We didn't use graphical cartoons, we didn't use any of that stuff. Our goal from day one was design a product for adults to use and only to be attractive to adults.
Okay. Well, the FDA will tell you that kids like flavored e-cigarettes. Now, it is true that some kids do vape flavored e-cigarettes. In fact, almost 100% of the market is flavored e-cigarettes. Why? Because unflavored e-cigarettes are unsatisfying, not only to kids, but to adult smokers. From survey after survey of adult smokers who quit, they will tell you that they were able not only to quit, but to maintain their smoking cessation, which is the gold standard, by using flavored e-cigarettes. The number one preventable cause of death in this country is cigarette smoking. We know how dangerous smoking is. The government has hundreds of millions of dollars to spend on it, but it hasn't solved the problem. So what more can we do? We've long known people die from the smoke. They smoke for the nicotine, which is addictive, but nicotine is not particularly harmful for a healthy person. It's the smoking, it's the products of combustion. And the FDA itself has authorized pharmaceutical nicotine gum, nicotine patches, obviously. It's just how do we deliver that nicotine in a way that satisfies adult smokers?
And that's why freedom of choice and having so many options for harm reduction is so important, is because if we're only limited to tobacco and menthol of a couple of flavors with a couple of devices, that is a complete failure by the agency. And the reason is because they're literally saying you can choose this flavor, you can choose that flavor, or you can choose to smoke, or you can choose the gum, or you can choose the patch, or you can just choose to quit. Those are your only options, right? And so as an adult, I hate that because I want to have the freedom of choice to be able to use whatever product satisfies my addiction to nicotine, knowing that I'm choosing a safer alternative.
This term that's been used around e-cigarettes, safer but not safe. The questions that everyone's interested in to really understand the full scope of the risk of these products, such as e-cigarettes, it's going to take a long time. And we're talking about non-communicable diseases, so cancer, cardiovascular disease, stroke, chronic obstructive pulmonary disease. So if we look at e-cigarettes, they contain flavorants, and those flavorants are classified by FDA as generally recognized as safe. But keep in mind that classification is based on ingestion in food products. So there's really no understanding of what happens when you heat those products and inhale them into the respiratory system. Then the liquid goes over a heating coil to create the vape that's inhaled by the user, and that heating coil appears to be a source of metals that have known health hazards. And then also looking at short-term clinical outcomes. So if we think about cardiovascular disease, after vaping, heart rate goes up, blood pressure goes up, and we find in the vape, say for cancer, there's constituents, a few examples would be acrolein or formaldehyde that have known adverse effects and contribute to carcinogenesis, and also the metals such as chromium and nickel that are known to cause cancers.
So after we went into scientific review, it was months and months and months and months and months that went by, right? And then boom, the news came. we received denials for all of our products that came out, and we were just lost. Did this company do a longitudinal and cohort study? No. Did this company do a comparative efficacy study? No. This was never a requirement for us to do, or we would have done it. Did I make a mistake? Or was this not a requirement and something has just happened here where they've moved the goalpost and said, hey, we want you to do this, but we didn't really tell you that.
The court arguments would focus on this question. Did the FDA give businesses fair notice of what is expected? Or did it pull a regulatory sleight of hand, changing its requirements for approval after the companies had submitted their applications?
And FDA had put out approximately 55-page guidance about what it would like to see in those applications. Typically, you would expect there to be a notice and comment rule established that would set forth the criteria of what's supposed to go in the application, and that would be finalized, and then the applications would go in.
Notice and comment rulemaking is a legal process that allows federal agencies to propose new rules or amendments and receive input from the public before the rules become final.
What happened here is you had this guidance, you had a proposed rule, and then because of other litigation, the deadline to submit the applications was actually accelerated from 2022 until 2020. And even then, the rule of what was supposed to be in these was still only a proposed rule. It had not been finalized. It was like a draft rule. The important thing from that is even that proposed rule didn't have anything about what became the crux of the litigation, this longitudinal comparative efficacy requirement for the non-tobacco flavored products.
The distinction in administrative law is between what's called agency guidance on the one hand and agency rules on the other hand. Those are treated as two very different things. And the legal distinction between guidance and a rule is that agency guidance is not supposed to be treated as hard and fast. The theory is that the agency is, in a sense, offering a tentative view of the law from which it can depart. It can make exceptions. It can be flexible and dealing with situations that it didn't contemplate. And whereas a rule is a hard and fast binding norm or requirement that binds not only the regulated public, but also the agency itself. And the FDA would say, in this case, it's been faithful to that line.
When you have small businesses and even large businesses, even some of the biggest companies in the world in this industry, they were going into this process thinking that they understood what it was that the agency wanted from all the guidance that FDA had supplied. They went in knowing that they had a finite amount of money to spend, each of them, and how they're going to spend that money and use their budget to try and put together the strongest application possible, because they had one chance at this. To be able to stay on the market, and if they failed, then their businesses were done.
They estimated that every application was going to cost $50,000. What they didn't say is that it could potentially cost $50,000 per SKU. That number of $50,000 ended up being about $500,000 per SKU. When we start to look at that and we say that a company could have anywhere between 15 to 30 flavors in their lineup, and a nicotine ranges of 3 milligram, 6 milligram, 12 milligram. Do the math. Now you're talking $10 million, $15 million. When they initially said, oh, we think these applications are only going to cost $50,000.
They put together voluminous applications for all their different products. And by court order, if they wanted to keep their products on the market while the applications were pending, they had to put those in by September 9th of 2020. And then 10 months later, in July of 2021, we learned subsequently, FDA internally decided that they were going to now impose a new and a different requirement that was not raised in any of the guidance that they had put out to the industry over the previous 4 or 5 years. It's what the court in the stay decision termed the surprise switcheroo. But the crux of it is, once the agency establishes a position here, saying things like a single point in time study will work and not saying anything about needing any sort of scientific study, if you, FDA, are going to require that, then at minimum, you need to give applicants the opportunity to go and conduct that study.
The core of the legal dispute drew heavily on foundational administrative law cases. In SEC versus Chenery 1, the Supreme Court held that agencies must defend their decisions based on the reasoning they gave at the time, not after the fact. In Chenery 2, the court upheld an agency's right to create policy through individual decisions, but warned against unfair surprise when regulated parties are penalized without prior notice of a new standard. Does limiting agencies to their original reasoning protect fairness and accountability? Or does letting them set rules case by case without warning undermine predictability for the regulated?
Well, Chenery 1 pervades the case throughout, right? Because the Fifth Circuit repeatedly found, and we repeatedly point out in our Supreme Court briefs, how the agency is engaging in post hoc rationalizations.
Wages and White Lion argued that the FDA changed the rules after applications were submitted, demanding scientific studies it had not clearly required before. The Fifth Circuit ultimately agreed, but the Supreme Court reversed that decision, finding that the FDA had consistently emphasized the importance of rigorous scientific evidence and had not violated Chenery 1 or 2.
The FDA didn't engage in any kind of switcheroo. Throughout, it has been focused on applying the statutory standard. The statute hasn't changed. The statutory standard lays down a standard of appropriate for public health, and then in articulating what the FDA should consider, the statute itself says consider the extent to which this new product will attract new users versus the extent to which it'll decrease the existing use of cigarettes. It's clear that nothing in the FDA's guidance prior to the deadline for submitting these applications articulated crisply that comparative efficacy requirement that I think the FDA will admit that it did apply. But the FDA will defend that requirement by saying it's in the statute. It's fairly discernible in the statute itself. If you look at the statute, you really can't come to a different conclusion than reading it this way. The companies could read the statute as well as we could.
The word efficacy is not there under the Tobacco Control Act. It's not part of Section 910 of the Food, Drug, and Cosmetic Act. There's a second issue to which I should mention, which is the overlooking of the marketing plans. Our clients put in a lot of very strong youth prevention measures. They sell their products only in age-gated vape shops. You have to be 21 just to walk through the door. They have restrictions in terms of online marketing. They don't use models that are under a certain age, that sort of thing, to really prevent youth interest in and use of their products. FDA overlooked the marketing and sales access restriction plans because, in FDA's words, in the interest of efficiency, that's what they were going to do, is just overlook them. That was arbitrary and capricious to overlook and not consider the marketing plans, because if you're looking at risks and risks of youth uptake, you sure better look at whether these measures will be successful in preventing youth initiation with the products.
And indeed, in the U.S. Supreme Court, the FDA concedes the error. So there's no question that it recognizes that it acted improperly in ignoring that evidence. The question becomes then, so what? Because if the answer is ultimately in the final analysis, it doesn't matter, i.e. the FDA would have turned down all of these applications, even if it had considered the marketing plans, there's a compelling argument, in my view, that this error, admitted error, was harmless. And which means that the U.S. Supreme Court should uphold what the FDA has done without requiring it to take any further action.
Justice Samuel Alito, writing for a unanimous court, stated that the FDA's omission did not constitute a harmful error that would warrant overturning the agency's decision. The court emphasized that given the substantial public health concerns associated with flavored e-cigarette products, particularly their appeal to youth, the FDA's decision was justified. The opinion did not alter either doctrine in Chenery 1 or Chenery 2, leaving agencies broad power to make policy either through rulemaking or adjudication in place. With the case settled in favor of the FDA, Wages and White Lion now face an uncertain future.
This decision will drastically change vaping as we know it today. I have a feeling that a lot of businesses of my stature will be gone. And I think that this market will just be left to the black market. The consumers have been given free choice to choose whatever products they like. And they like ours. And the thing is, if the public has told you what they want and what they like, why are we not doing things to help them?